Start. The learned senior counsel further contends that the Safarsi Act was enacted by the Parliament under entry 45 of List 1 of the Constitution of India. It is a special act with a special purpose and procedure laid down for the recovery of the secure asset of the debtor by the bank to recover the amount due to it, and thus any encroachment upon this act should not be permitted, as it would defeat the laudable object of the act which has been enacted, keeping in view the larger public interest. Mr. Vikas Singh, the learned senior counsel, appearing on behalf of the respondent, State Bank of India, in the appeal arising out of SLP under bracket C number 28040 of 2015, contains that the SFRC Act cannot be allowed to fail at the hands of the present appellants who have no registered instrument of lease. The learned senior counsel further contends that in light of the decision of this court in the case of Harsad Shupra, the present case is barred by rejudicate. He places reliance on the three-judge bench decision of this court in the case of Bhanu Kumar Jain versus Archana Kumar and another under bracket 2005 SCC 787, wherein it was held as under. It is now well settled that principle of res judicata applies in different stages of the same proceeding. It is well settled that principle of res judicata can be invoked not only in separate subsequent proceedings, they also get attracted in subsequent stage of the same proceedings. Once an order made in the course of a proceeding becomes final, it would be binding at the subsequent state of that proceeding. We find in the present case the Tahsildar reopened the very question which finally stood concluded, viz. Whether respondent one was or was not the tenant of the suit land. He further entered into a new premises of reopening the question of validity of the premise which could have been in issue if at all in appeal or revision, by holding that compromise was arrived at under pressure and allurement. Thank you.